Thank you.
The judgment in the appeal, Healthcare at Home Limited and the Common Services Agency.
Lord Reid will explain the decision of the court.
Under EU law, contracts in the public sector have to be awarded without discrimination between tenderers from different member states. That is an aspect of the creation of a single market. In order to ensure that there is no discrimination, EU law requires the process of awarding public contracts to be transparent. In particular, the invitations to tender issued by public authorities have to make clear the criteria on the basis of which tenders will be assessed and contracts awarded. In its case law, the European Court of Justice has said that the contract documents must be formulated in such a way as to allow all reasonably well-informed tenderers of normal diligence to interpret them in the same way. EU law also entitles unsuccessful candidates for the award of a contract to be informed of the reasons for the rejection of their applications. These requirements of EU law have been implemented in the law of the UK. This appeal is concerned with the award of a contract for the provision of public health services. The appellant, Healthcare at Home, is a private health company, and the respondent, the Common Services Agency, purchases health services on behalf of the NHS in Scotland. The appellant was the existing supplier of the services in question, but it was unsuccessful in a tender competition for a replacement contract. The appellant complains that the criteria for the award of a contract were not made sufficiently clear, and that the reasons given for the rejection of its tender were also lacking in detail. Before the outer house of the Court of Session, the appellant led evidence from witnesses involved in the industry, mostly members of its staff, to the effect that they had not understood the criteria in the same way as they had been applied by the agency. The judge, however, held that the criteria had been sufficiently clear to allow all reasonably well-informed tenderers of normal diligence to interpret them in the same way. He also held that the reasons given for rejecting the appellant's tender were adequate. An appeal to the inner house was refused, the court holding that whether the necessary standard of clarity had been met was a question to be determined by the court, applying its own judgment, and did not depend on the evidence of witnesses as to how they had understood the document. The inner house also considered that the reasons given had been adequate. Healthcare at Home now appeals to this court. Its principal argument is that whether contract documents allow all reasonably well-informed tenderers of normal diligence to interpret them in the same way should be judged on the basis of evidence as to how the documents were in fact understood by actual tenderers, not according to how a judge thinks that they would have been interpreted by a hypothetical tenderer. It also argues that the lower courts erred in concluding that the reasons given to it were adequate. The Supreme Court unanimously dismisses the appeal for reasons set out in a judgment written by myself. On the main point, it's clear from the case law of the European Court of Justice that the test of a reasonably well-informed and normally diligent tenderer is an objective legal standard applied by the judge. The question is not whether all tenderers actually interpreted the criteria in the same way, and whether, if not, they were all reasonably well-informed and normally diligent. The question is whether the court considers that the criteria were sufficiently clear to permit of uniform interpretation by all reasonably well-informed and diligent tenderers. An approach which depended on evidence of the actual subjective understanding of tenderers would undermine the principle of legal certainty and the requirement that any review of a tender process should be carried out as quickly as possible. In order to apply the standard of a reasonably well-informed and normally diligent tenderer, the court has to make its own evaluation. It may well have to hear evidence in order to do so. Evidence, for example, as to the meaning of technical terms used in the contract documents, and as to the context in which the documents have to be construed. But the question that the court has to decide cannot be determined by evidence, as it depends on the application of a legal test, rather than being an inquiry into a question of fact. The courts below therefore applied the correct legal test to assess the clarity of the award criteria. In these circumstances, it would not be appropriate for this court to interfere with the conclusion which they reached in the light of their evaluation of the evidence. Similarly, in relation to the adequacy of the reasons given to the appellant, the courts below followed the approach laid down by the European Court, and there is no basis on which this court could properly interfere with their conclusion on the facts.
Thank you. The court is now adjourned.